The case then that we're going to hear next is State of Ohio versus Brian Drurey. It's case number 18CA0098-M. Both parties are represented by counsel, so each will have 15 minutes to present your argument to the court. Appellant, of course, may reserve up to 5 minutes. Be familiar with the television that has the clock on it. Although I do caution that while it says rebuttal, that top timer represents the total time. So if you're going to reserve 5 minutes, when that hits 5 minutes, you're at your rebuttal time. Okay. If there are children or victims involved in this case, we ask that you use initials, and also ask that you stay at the podium, keep your voice up so we get a good recording. And we have read the briefs, counsel, and are prepared to proceed if you are. Thank you.
May it please the court. My name is Brian Smith. On behalf of the appellant, Brian Drurey, I'd like to reserve 5 minutes for rebuttal.
All right, thank you.
Your Honors, there were 5 assignments of error raised here. I'd like to talk briefly about the motion to suppress. There were two challenges incorporated in the motion to suppress. One was whether there was reasonable suspicion to detain the defendant, and whether there was probable cause to arrest him. The main issue in this case was that there was not proof, was whether Brian Drurey was driving the vehicle on the night in question. This is a case where there was an accident scene. Police were dispatched to an accident scene. By the time they arrived, both of the occupants of the vehicle were out of the car, and they were detained at different locations near the accident scene. The state relied on the testimony of, first of all, the officer's testimony was not enough to establish which of the two individuals was driving the car. The state relied on the testimony of an eyewitness in a house that was sort of adjacent to or down the street from the accident scene, Tiffany Booth. Booth did not testify at the suppression hearing. The officers, I believe, Reed and Chafin testified. And there was never any statement that was made by either party that they were, that night, they were the ones driving the vehicle. So it's based on, the state's case was based on trying to deduce from footprints, from the context of the stop, who was driving that night. And the state never met its burden showing that there was reasonable suspicion to detain in that case, and also that there was not probable, they never met their burden that there was probable cause to arrest. I'd like to...
So let me just interrupt. At the suppression hearing, the only witnesses were the officers, so Goodwin didn't testify?
Correct.
And Booth did not testify at the suppression hearing?
Correct.
Okay.
Yes. Booth testified at trial. And that leads me to the third assignment of error, which was Booth had a prior theft conviction. The defense made an offer of proof to bring the conviction onto the record. The trial court decided not to allow the prior theft conviction, which I believe was from 2015, to be submitted into evidence. Booth was the only alleged eyewitness in this case. The officers arrived after the fact. By the time the officers arrived, as I said, both of the occupants were out of the vehicle. There was no direct proof that either of them were driving the vehicle that night. Of course, neither driver admitted to officers that they were driving.
Counsel, when you say she was an eyewitness, my recollection was that she called the police, and her testimony was that she saw a tall, thin silhouette get out of the passenger side. Did she actually see the car go off the road, or the accident itself?
Well, that's no, because there was actually conflicting testimony in that regard, Your Honor. When she called the the state played, or the recording of the call to dispatch was played at the trial, where she says, I was sitting in my room and I heard a noise. I believe she described it as a bang or a crash. But at that point, she's saying, I heard a noise. She's not saying that she saw an accident. So
her testimony was really limited to, I saw a tall, thin silhouette guy on the passenger seat.
well, and that's what the state had to rely so heavily on, was her description of this silhouette, or this, of what the body type was of the person supposedly getting out of the driver's seat of the vehicle. The problem is, it's at night, it's dark out, it's around the beginning, it's in March, so it's dark out, it's snowing heavily that night, and it was established that she was some distance away from where the accident took place, because it took place in front of a neighbor's house. So she's about, probably, she's some distance away. There was a question as to whether it took place under a street lamp or not. I think that there was some conflicting testimony there. So her testimony is unreliable for different reasons. And the problem is, when you don't admit a prior conviction, this is something that changed the complexion of the entire case, and changed the complexion of the state's case. Because without that theft conviction coming in, the jury has no reason to doubt her credibility. If that theft conviction comes in, all of a sudden, this changes the outcome, because the state is going to look at her testimony with suspicion. And it's going to show that she had a conviction for a crime of dishonesty, so now all of a sudden there's a reason to doubt her testimony. So you combine the fact that she's the only alleged eyewitness with a prior criminal history, which, by the way, was in the same court as the trial that was taking place, so that shows that there's even more of a motivation for her to cooperate. So all of these factors come into play to show that there's an abuse of discretion taking place on the part of the trial court in not allowing this theft conviction, which is fairly clearly admissible under Rule 609A3 from coming in. And I think that more than any other factor really changed the outcome of this trial. Now, I'd also like to talk briefly about the decision not to allow Matthew Rinn's testimony. Mario Goodwin did not testify in this case. He was subpoenaed for trial. The defense subpoenaed him. Matthew Rinn, the defense made an offer approved for proffer for Matthew Rinn's testimony. Matthew was prepared to testify that Mario Goodwin told him that Mario was driving the car on the night in question. Now, all of the conditions were met for this statement to come in as a hearsay exception where the declarant was unavailable. The statement was reliable, it was against Mario, and in fact, frankly, subjected him to criminal liability because of the citation for the accident. And there were reasonable means taken to secure Mario's appearance at trial. And now the judge decided not to allow the testimony on the grounds that, well, we can get Mario here, we can send an officer out to pick him up at a detox facility and bring him back. But at that point, he'd already been subpoenaed and reasonable means had been taken to secure his appearance.
I think the state argued that defense counsel declined that opportunity, though.
Well, at that point, it's not necessary. It's not necessary for that to take place because he's already been subpoenaed. At that point, he's already.
So the court says, hey, here's a witness that's been subpoenaed. We're going to take a break. I'm going to send an officer out to pick him up for you, Mr. Drurey. Defense counsel says not necessary.
Well, and that's the problem. There is too. At that point, Mario Goodwin's in a detox facility, so this may cause an issue as to his capacity to testify. It may cause an issue as to his availability to testify. At that point, none of the parties know exactly what his medical condition is or his state of mind to where he's even going to be a competent witness at that point. So I think that also comes into play, was not only that he was unavailable, but exactly where he was at the time of trial. So all of these conditions were met for the testimony to come in under a hearsay exception. Again, Matthew Wren, he's sitting in the lobby, he's willing to testify, and the trial court uses their discretion in not allowing that testimony to come in. So, just briefly, I want to touch on the convictions were also against the manifest weight of the evidence, simply because Booth's testimony was inconsistent. There were a number of factors calling her the veracity and the credibility of her testimony into question, and there was no proof that Brian Drurey was driving the vehicle, and never admitted he was driving. So I'd like to reserve my remaining time for rebuttal.
All right, you'll have 5 minutes for rebuttal.
Thank you.
Please the court, I'm Tom Morris. I represent the city of Wadsworth, state of Ohio in this case. Simple case, it's an automobile accident. Both passengers were intoxicated. Both occupants were intoxicated. There's a large man, and I want to bring this up because of identification purposes, who weighs 350 pounds. The other man weighs 200 pounds less than that. And there's an eyewitness that says, I saw the skinny tall man, or silhouette of that, leaving the passenger side. The jury's heard that. The jury believed that the larger man was in the driver's side, tested over the legal limit, and was arrested for operating under the influence of alcohol. I want to touch on the last thing first that he talked about. He talked about this, it wasn't the last thing, but this subpoena issue. He says none of the parties know the capacity. How do we learn the capacity? The state of Ohio wasn't even on notice that he was going to try to bring in this 804 evidence. That he was not able. All we see is a subpoena that goes out to a Mario Goodman, does not get returned, it is served, and then the next thing we know, we have a person we've never heard of, Matthew Wren, who's going to testify about something that we have no knowledge that he's going to testify to. There's certain parts of the rules which suggest that we have to have some fair notice of these things. Secondly, the court said, okay, take time, let's go get him, and let's see if he's competent to testify. And then you got to look at why was he out of the jurisdiction in the first place? Because the defendant took him out there. And put him in outside the jurisdictional limits. Certainly there's some issues on that. Talk about the prior theft conviction. The prior theft conviction was Miss Booth. Miss Booth did not, she testified, she didn't know either of the parties. In fact, the person that she wanted to call police was the police. She had a theft charge from that same police department 3 years earlier. And it wasn't really an issue whether she was lying or not. Credibility wasn't the issue. It was opportunity to see. And where were you when the accident occurred? She heard the accident, then went out and looked out the window and saw what was going back there. Given the fact that her credibility wasn't the issue, but rather it was the opportunity to see being the issue, the judge made the finding that the probative value did not outweigh the prejudicial value, and he has every right to do that under Evidence Rule 403. There was talk, wasn't talked in oral, but certainly on the brief, about the juror. There was a juror that 15 years earlier had been a prosecutor, didn't do OVI work, and that somehow should have been released for cause for no other reason other than she used to be a prosecutor. Well, certainly being a prosecutor, being a judge, being anything does not preclude you from service and jury duty. She was asked all the appropriate questions and answered them appropriately. If you don't want to have an attorney on it, you save a peremptory. That's what you do to kick off somebody who you may not want or you may think may have for trial strategy not want to have on there. So as to the motion to suppress, there were two witnesses, and I think what the complaint was is that Ms. Booth didn't testify. She testified at trial. That was beyond a reasonable doubt standard that we have. This was just, did the officers have probable cause? And in that case, the officers had talked to or had been relayed that there was a skinny guy that left the passenger side, so the big guy was at the driver's side. That gives the probable cause to believe, so that's one thing. You had both people, both the defendant and the other person who confirmed that they were the only two there, and they both said the other guy was driving. So now we're looking for probable cause. Both were under the influence based on the factors and the training that the officers had. That gives you probable cause to believe when the car is registered in his name, into the defendant's name, that the other passenger says he was driving, that a witness, a third party that doesn't have a dog in the fight, says that gave evidence to suggest that the larger man was driving. That gives us probable cause to get us in the trial. And then, frankly, the jurors didn't believe Mr. Drurey. They said that he was driving. They said he did have a prohibitive breath alcohol concentration, and he did not have control of his vehicle.
Was there anything in the record that would indicate the driver's side door, due to the accident, was unable to be opened or was in some way damaged?
No, not that I know of. The other issue we talked about the doors, or the seats, was the position of the seats, somehow how indicative, and the officer said that was inconclusive. So they did a little bit of legwork on that, didn't see it, but both doors were working. If there's no other questions, I'll yield my time.
All right, thank you. Counsel, you'll have your 5 minutes. Thank you.
Tiffany Booth did not say she saw a skinny man. She was not able to conclusively identify which individual got out of the driver's side of that car. She testified that it was a silhouette. And not only that, you know, again, it's snowing that night, it's dark, she's some distance away from where this accident took place. And quite frankly, there was testimony, it wasn't even conclusively established where she was when the accident took place. On the phone call, she says she's in her room and hears a noise. In trial, I believe in her written statement, she testified that she gave two different versions of where she was. I believe at trial, she testified that she was outside shoveling snow, and in her written statement, she gives a different version. I believe she said she was in the house. So there are two differing accounts of what took place, and I think that further calls her credibility into question. And I think that just underscores the need for the jury to know about this prior conviction, and that information was not made available to them. Now, as far as Matthew Wren, I believe he was listed on the witness list. Obviously, again, Mario was subpoenaed. Matthew Wren, I believe, was subpoenaed as well. There was notice provided, so the state had noticed that he's going to be a witness of some kind of trial, and frankly, the state has an opportunity. He's standing in the lobby, they can voir dire him if they're not sure what his testimony is going to be, if there's a proffer made as to his testimony. Now, so just getting back to this, Booth's credibility was an issue because of this prior conviction, and especially because it's a crime of dishonesty. This isn't littering, this isn't disorderly conduct, this isn't, you know, some unrelated matter. This goes directly to her credibility and her believability as a witness. And frankly, the fact that it's a conviction out of Wadsworth Municipal Court just underscores that the jury needs to know about it, because at that point, you know, with a prior record, she may have a motivation to, you know, having served jail time or having a prior conviction, that she may have a motivation to cooperate with the city of Wadsworth, with the prosecutor's office, or with the police department. So I think that's something.
You're not pretending that she had an open case at the time.
The case wasn't open at the time, Your Honor. However, it was admissible. We would submit that it's admissible under 18CA0098 because it had happened in the last 10 years prior to the case. I believe it was approximately 3 to 4 years prior to the case, and it was close enough in time to where it would be probative of her credibility. So that's what we would submit there. The seats, the driver and passenger seats were in the same position. So just touching on that briefly, that doesn't really provide evidence either way as to who was driving. I think it just further shows that it was inconclusive as to who was driving the vehicle. And very briefly, with respect to the juror used, it wasn't just an appropriate response or appropriately responded. The juror used the exact language of, "I can be fair and impartial." And I think I think the fact that the juror used the exact language during voir dire that the trial court would want to hear to show that that person was credible, kind of calls their, kind of shows their eagerness to serve on a jury, and I think shows some bias on the part of this juror that would support a challenge for cause under these particular circumstances. And by the time she was called up, the defense had already used their peremptory challenges. And I'd be happy to take any further questions. Seeing none, we would ask this court reverse and remand. Thank you.
Thank you both for your arguments this morning. The court will take the matter under advisement. We'll issue a decision in due course. The clerk of courts will certainly mail each of you a copy of the decision on the day it's released. Opinions are also posted on the Supreme Court of Ohio's website. Now, the court will next